this is our third session of Washington Arbitration Week. It's the second edition, and we are truly thrilled of doing our first hybrid session now from Allen and Overy with my former colleague Gaila Gehring Flores and my former colleague Kelly Bolena. We met many years ago, and they're true to international arbitration and of course true to my heart. One thing that is important to bear in mind with regard to what we're living is that these hybrid experiments seem to be more than a transition into the new normal. As we have seen, the new variants are now in place. Japan has closed its borders. Other people have had to delay their travels to Europe, etc. And it seems that we're going to have to adjust with creativity into what might be the new normal. It might be that we'll have to vaccinate each year and find ways of getting together, both for work and family, etc., in this type of environment. So without further ado, I would like to simply introduce Gaila Gehring Flores, who is our host, together with Allen and Overy, who have basically invested time and creativity, thoughts into how to make Washington Arbitration Week a successful forum and in a hybrid environment. So just to say a few words of Gaila, she is a champion of international arbitration, but also a champion of diversity, innovation, and creativity, both in drafting and also while at hearings. I'll stop there because I know that I'll be reprimanded if I keep on going, but I'll give the mic now to Gaila, and thank you for having us.
Thank you so much, Jose Antonio. Thank you for everyone being here today at this hybrid event. It is an absolute honor to host WOW's second annual International Arbitration Conference, and certainly it's an honor to host its first hybrid panel. As Jose Antonio mentioned, we are in very interesting times today, and what better panel to be the first hybrid panel than holding your own seamless, efficient, and innovative international arbitration. What better panel than to have the first hybrid be this panel? Why? Because behind all of those adjectives, seamless, efficient, innovative, is the question behind every great idea, which is, how do we make this work? And this absolutely stellar panel that we have for you today, both in person and virtually on Zoom, this absolutely stellar panel is full of people who answer that very question. How do we make this work? In any circumstance. So we have people here today who've been working to solve that question. How do we make this work in international arbitration with excellence, with innovation, with creativity, efficiency, for over the past 20 years? These are the people we need to be listening to when asking, how do we make international arbitration work, and how do we make it work better? Because no matter what we throw at them, they make things work. And today is an example of that. And today's moderator is an example of that. And that's Ashley Rivera from Crowell & Mooring. She's been working at Crowell & Mooring as counsel, and she's been working in international arbitration for the past 15 years, probably over 15 years at this point. And she, of course, like all of us in international arbitration, has been working with the question, how do we make this work? And today she's here to introduce this panel and to moderate this panel. Thank you, Ashley, and thank you everyone for being here today.
Thank you, Gaela. Thank you, Jose Antonio. We are very excited to be here with you today. I'm here with a wonderful panel. We have an array of perspectives to offer our audience. We've got perspectives from large law firms, small law firms, the institutions, and from vendors. So you'll get to hear and benefit from all of their insights. So sitting on the end is Ms. Stacy Gelman. She is an arbitration specialist. She has a law degree, but she is not licensed to practice. And she has worked in international arbitrations for over 15 years at Crowell & Moring. And she has participated in more than 30 arbitration hearings. Next to Stacy is Kelby Belena. He is an international arbitration specialist who recently joined the Americas group with Allen & Overy after 15 years at Arnold & Porter. Kelby dedicates himself to training junior paralegals and exploring technology innovations, and he had a very heavy hand in helping us set up this wonderful panel today, so thank you, Kelby. Next to Kelby is Jackie Argueta. She is an ICSID paralegal with 7 years of experience in investment arbitration, and she previously worked at 2 large law firms and specialized in investment arbitration and in commercial arbitrations. And then we have our vendor perspective from Christine Falciccio, founding principal of Sopra Legal, which creates hyperlinked indices, hearing bundles, and other written submissions for its clients. Christine also serves as the vice president of the Global Steering Committee of the Campaign for Greener Arbitrations, and she will be sharing more about that campaign with us later today. So as far as the panel format goes, we have a lot of topics to cover. We will leave some time at the end for questions from both the in-person audience and from the Zoom audience. The Zoom audience will need to type their questions, and we will get to as many as we can at the end, but I'm going to just jump right in. I know we have an array of experiences in our audiences, ranging from people who have been in the field for decades down to law students who are trying to figure out if this is a field they would like to join. So Kelby, what is an international arbitration specialist?
Sure. Arbitration specialist is usually someone who's going to be specializing in international arbitration, but more so, there are a lot of firms that don't have a dedicated paralegal, legal assistant, who name it, but someone who is actually going to specialize in a lot of the work, because some of these cases can last for years, and you could go through, you could have somebody dedicated, maybe an intern, come in for a year. A lot of what they were going to do that year is going to change. So somebody who's in international arbitration, paralegal specialist, legal assistant, is going to sort of follow the case from the procedure order to the discovery phase, filings, hearings, and all of it has its kind of magic. And in that, hopefully, we're saving costs to be more efficient. There's also such a more of an administrative role to it, but it's also kind of advising the legal team as to how this should proceed, because there's a lot of nuts and bolts that really have to happen. You don't want to, for instance, ground yourself to commit to maybe some translation requirement, and later down at the hearing it's going to sort of bite you.
Now, Stacy, you are the International Arbitration Specialist at Crowell & Moring, which means you work for any arbitration that's going on in the firm, and I know frequently you work with attorneys who have not run arbitrations before. So what is it, how do you integrate yourself into their teams? How do you convince them that they need you to succeed?
I think the number one thing is just keeping me involved, being on all communications, attending team meetings. Fortunately at Crowell, I am lucky that most teams do that. You know, I'm on all client correspondence, I'm all institution correspondence, all internal team correspondence. I'm invited to all team meetings. And that really helps for me, one, to feel integrated into the team, and two, to try and keep the team on track, because that's a big part of my job, is just keeping the team on track and making sure deadlines are being met, and things are moving and things are happening. A lot of what I'm doing and what I'm trying to do is to help keep credibility for the attorneys with the tribunal members, particularly for those attorneys, who are new to international arbitration and may not just be familiar with things such as terminology. For anybody who works in international arbitration, you know our terminology is completely different than anyone from litigation. So you can't just make that quick switch. If you're coming in and from litigation and someone says, hey, let's work on the memorial filing, somebody in litigation is going to look at you twice and you're going to have to explain what you're doing. So, being able to do that really does help keep the credibility with the tribunal if, we can present, in a positive and knowing front.
That's great, thank you. And then Jackie, maybe you can offer here the institutional perspective. Can you tell when a case doesn't have an arbitration specialist? Do teams have to have arbitration specialists to succeed?
Well, first of all, thank you for inviting me to this panel. I'm really excited to be here. As you all know, I work for ICSID, a part of the World Bank Group, and something very unique about ICSID is that we really strive to make sure that all of our cases move forward as effectively and efficiently as possible. So even if one of the parties or both of the parties don't have all of the specialized resources that will be discussed here today, if it's a small firm, a big firm, medium-sized firm, ICSID really strives that when a party comes to ICSID, they can count on the secretary of the tribunal, the paralegal, the legal assistant, who will make sure that the case moves forward as effectively as possible.
That's great. And then Christine, so you have a unique perspective working as an outside vendor with these case teams. When should we be getting you involved? At the very end, just before the hearing?
So I beg you not to do that. Well, as early as possible. That's the simplest answer. I think my advice for anyone who works in a role like Stacy's or Kelby's, where you are preparing the team, is to add that to your standing to-do list, to reach out to any vendors that you may potentially need, translators, a hot seat operator, someone like myself to do the hyperlinking. Once the schedule is established, you can let us know of upcoming dates, and it's most appreciated when you do so. We are certainly many times on the receiving end of those urgent last-minute requests of things that do fall through the cracks, but I think as a best practices advice, it would be to just get us in at the onset of a matter. And we know that sometimes the schedule might change, and that's to be expected, but at least we have a little bit more of a heads up before that day of filing. So.
And since our panel topic is partly about seamless and efficient, is it more cost effective to have you looped in sooner rather than later as well?
So again, I'm speaking now on behalf of my company and how we run things, but at Sopra, there isn't necessarily a cost difference coming in later, but it's just one of those things that would definitely reduce the stress levels of everyone involved if you do have plans in place for just thinking broader scope of what you're going to integrate into the arbitration, and then again line up the support that you may need. Even if you think that you might be able to cover it in-house, you can always reach out to a vendor to have them sort of ready to go if needed.
Right. So now we've talked about the benefits of having an arbitration specialist, and if you're at an institution like ICSID, there are guardrails in place to still help parties succeed, irrespective of whether they have the resources of having a specialist. But I think it would also be a good idea to talk about what some of the pitfalls can be if you don't have that consistent perspective that Kelby was talking about, if you don't have that person who has the long-range planning about how to run this case, what the deadlines are, how they're getting met, how to incorporate vendors in a timely manner. So Kelby, what can go wrong if people don't have an experience?
A lot can go wrong, and I try to do my best job to make sure that it looks like nothing went wrong. But I love my vendors. I love the idea of what it's going to look like at the end when I'm starting a case. For example, when I'm imagining what the hearing is going to look like, how is this person going to be cross-examined? This person might only speak in Spanish, but there's a bunch of documents that are in English. Have I thought about what needs to be done for this cross-examination to even happen from the beginning. Do I have video files that have some kind of transcript when we actually try to read it out loud? Just a lot of like little stuff. And what happens when you have an inexperienced legal team? I can tell from right away. Translations have been submitted in parts all over. Maybe an exhibit has been submitted in one chunk, but in like 10, 20 different parts. And I already know that this is going to be kind of complicated. I need to clean it up somehow, maybe resubmit it in a nicer, cleaner way, because in the end, it bites. It bites us, and we really have to find a way to make our case presented in a more cost-efficient way, a more effective way. Do I want to cross-examine somebody 5 years from now with 5 different binders and all this stuff of trying to ask questions, or do I want to say, okay, here are the 10 that I really need to focus on? And in the end, I think it'll be kind of work a little bit more seamless that way.
So when are you thinking about hearing preparations? Is it just before the hearing?
No, from the beginning. From as soon as I get that first, or I'm going to submit that first request for arbitration, I'm thinking, how is this going to look? Like, do I just want to like submit an exhibit that's just a scan of something? Do I want to make sure that I've saved the source, the date, the title, everything that I need to know about this document? Because I might go back to it. I might have questions about it. That I might need to put it on screen. So do I have a good quality of this document for the screen, for distribution? A lot of like little things that we're thinking about. I'm thinking from the beginning, how is this going to be presented? And especially if you're thinking about a lot of witnesses, experts aren't very experienced in doing arbitration like this. It might be their one time. So you want to make this also as easy for them as possible. If it makes sense for them on paper, these are my 10 exhibits, I get what I'm trying to say here. Here's my source. This is the date that I had this. It makes it so much easier because sometimes the hearing might not happen like until 5-10 years from now, and then it's sort of like, what was this document even about?
Now, Stacy, have you worked on, or maybe you can talk about the perspective of working on a case where you are here, you're looking at these long-term considerations from the beginning, but perhaps opposing counsel, the opposing party, does not have an arbitration specialist, or they have not actually worked on an arbitration before. And so how do you work with that opposing counsel to try to still keep things running smoothly from the arbitrator's perspective?
So honestly, it takes a lot of patience, but it also takes a lot of kind of fortitude. Ultimately, I'm never going to do anything. I'm never going to suggest anything, and I'm never going to encourage anything that is going to be detrimental to either law firm, the tribunal, or more importantly, any of the clients. Everything we're doing is trying to make things run smoothly and efficiently. And we have been in instances where we've had an opposing counsel, for example, who did not practice international arbitration and did not have an arbitration specialist. And we got to the point of the hearing, and we were trying to create the hearing bundles. And the opposing counsel, unfortunately, just kept fighting with us. We don't need these bundles. We don't need these bundles. We don't need these bundles. And we weren't, unfortunately, at an institution like ICSID, which would encourage the hearing bundles. So it was myself and the partner from the opposing law firm who were constantly on the phone daily about, why do we need these bundles? Why do we need these bundles? And I finally, just kind of insisted that this is international arbitration. This is how it's done. We're just trying to make this easy. And once we finally agrees to have the hearing bundles, of course, the next step is the organization of the hearing bundles. And of course, we went through the same thing there. There was arguing back and forth, until we finally just said, this is what we're going to do. This is how it's done. And, if you don't like it, then please bring your own exhibits, how you plan to use it. But this is what we're going to present to the tribunal. And we had the hearing went great, and it was in front of a sole arbitrator, and at the very last day, on the record, the arbitrator says, this was absolutely fantastic, these hearing bundles were wonderful, I'm so glad we had them, they were so well organized, and this hearing went so much easier than I ever could have expected with the documents. So again, like I said, we're not trying to do anything to make things difficult, we're just trying to do things to make things run smooth and easy, and that's what we're here to do.
Well, and I was at that hearing, and what he said was it was the best hearing bundle he had ever seen. All credit to Stacy. And I will also say, you might have heard Stacy was the one interacting with the opposing partner because I was busy prepping for the hearing, and I have my specialist. I don't have to be on the phone arguing with opposing counsel over this because Stacy knows it better than I do. So she's got her lane that she is absolutely expert in, and I rely on her. Stacy and I have worked together for 15 years. I rely on her daily to make things run how they're supposed to. And so having an experienced player on your team who knows this better than you do and you can delegate and rely on saves you time. Clients don't want to pay for my billing rate to be arguing with the opposing counsel about the hearing bundle. So that's just one more perspective on that. Now, Christine, you have a unique experience on this, and you've touched on it a little bit, but can you talk about the hyperlinking of briefs and how this can also increase the efficiency of the process, especially as you're going into the hearing, and what considerations parties are thinking about when they're seeking out your services?
Sure. So again, the hyperlinking, all the work that we do, it was for a while somewhat novice and not really accepted. Now it has become more commonplace. I think that everyone here is obviously familiar with it, and obviously most of you in your practices, you'll do this just without a doubt on your indices. But then when it comes to some of the additional written submissions, a couple notes on this. As far as pitfalls and what might go wrong, sometimes we receive things that have been started in-house, and maybe, again, because it's not somebody who's as well versed in all of this as my co-panelist, it might not work when you try to use it on another computer or when you try to send it to the arbitrator. So you never want that to happen. We sometimes have to repair that and fix things up. So we've been through those experiences. The other part of it too, when I thought of this, was just the experience of not always assuming that we have to stick with it's just hyperlinked indices. I have clients who just proactively decide to hyperlink the rest of the written submissions. We actually had a case that I was just thinking about over the weekend recently, where one party decided to go and hyperlink one of their written submissions, and the tribunal received it and then asked for them to go back, both parties to go back and hyperlink everything, expert reports, witness statements, all of that. So this touches on what Kelby mentioned as well, and Stacy, with just having that mindset of what may help here. How can I present this in the best way? So again, if you have those resources in-house, tap into them to think about how you can present your case, but also if you're not so sure about it, reach out and try to have an external specialist help you.
And Jackie, you touched on this a little bit already, but ICSID has a lot of resources to help parties avoid some of these pitfalls that we're talking about, and maybe you could just touch on that briefly.
Well, at ICSID, we're really lucky because by the time that the final product gets to my desk, it already looks pretty good. So I don't have to deal with a lot of the issues that my co-panelists have to deal with. But definitely ICSID has a lot of resources available, both on its website and also if you reach out to the secretaries of the tribunal or myself, the paralegals. Of course, good communication, understanding expectations, and anticipating potential difficulties, I think, are key to avoiding a lot of pitfalls. But again, like I said, ICSID has a lot of resources, both the individuals at ICSID and on our website.
That's great. Now, one theme that has been running through this panel is relationships. And so how important are relationships, and which relationships? Like is it just you versus you and the paralegals at the institution? Like, what are the sorts of relationships that are required to have an arbitration run seamlessly? Kelby, would you like to touch on this?
Sure. It's really important to have some kind of relationship with a paralegal, on opposing counsel, at ICSID, vendors as well, because we're all sort of on the same goal. We're not making legal arguments, and we're not trying to kind of win our case simply by how we hyperlink or organize our files. We really wanted to run as smooth as possible, but if you've got one folder structure, I've got another folder structure, it's going to clash. So it's great to sort of reach out to the other side, reach out to see what, ICSID has on their website. This is how they do a structure, but the DCA might not have that, or ICC might not have that, they may. So it's always sort of like reach out to find out what is the sort of the requirements, what is the PO, for initial procedural order, say if there's something different, because you want it to run smoothly. You do not want to get to the hearing and then, oh, we need to restructure everything. We need to, this is where we get a vendor involved, hyperlink everything because the initial record didn't make sense and now we have to fix it. That's one of those the things that it's very important to reach out and have some kind of relationship, and I hope always in the future, especially when someone's starting their kind of career as a paralegal in this field, they do sort of reach out with permission, of course, with their attorneys, that they know that they are reaching out, but the end goal is that we're not sharing this kind of information. We're just trying to make sure that we're sort of all on the same page so that when we file, everything sort of works correctly.
And Stacy, what about your long experience? How do you bring that to bear in benefiting your case teams, specifically with specific arbitrators? I mean, you've been in 30 hearings. You said, I'm sure Kelby has been in dozens of hearings as well. Do you get in front of the same arbitrators again and again, and how does that benefit your teams if you do?
Oh, absolutely. We've definitely been in front of certain arbitrators multiple times, and it's just knowing and anticipating what they're going to want. Not only what your case team and the opposing case team is going to want as far as organization of the hearing, but what the arbitrator is going to like, what their preferences are going to be, whether or not they like things in hard copy, whether or not they like things hyperlinked, just how they like to conduct a hearing, how they, just their general preferences. And the nice thing is, if you've been in front of an arbitrator before, one, you can talk to your team about that because you may have some team members on your team who were not in front of that arbitrator previously. So, you can absolutely share your experiences with your own internal case team. It helps with building the procedural order number 1 because you can tailor it specifically to the preferences of that particular arbitrator, particularly if that person happens to be the president of your panel and you know how he or she prefers things. So that also makes things a lot more seamless as you're going through the hearing. It always benefits. Experience absolutely benefits.
Great. Okay, so let's shift gears a little bit here. We've been talking about how cases run in general, but as we all know, back in March of 2020, the legal profession, along with the rest of the world, was thrown a big wrench in how things are normally done. So COVID has been a bit of a game changer. And for those of you who were able to log into Meg Kinnear's welcome speech this morning, you heard how ICSID as an institution has pivoted towards the virtual space. So the panel thought it would be a good idea to address some of the tips and tricks that we've picked up over the last however many months at this point. I've lost count. So let's do a quick poll. Kelby, how many hearings had you been in virtually before COVID? 0. Stacy, how many hearings?
0.
Jackie?
Well, there's a longer answer. So actually, before COVID, ICSID had been doing some shorter hearings virtually, some hearings on provisional measures, things like that, and also some of our in-person hearings often had a virtual component where one witness or expert would be testifying remotely. So yes, when COVID happened, it definitely changed everything, but ICSID already had a lot of things in place to make that shift to a all virtual space.
So you had some experience.
Yes,
okay.
That is the answer.
So now, post-COVID, how many hearings have you done? Virtual hearings?
At least probably 6 or 7, right?
I've done 7 virtual hearings.
7, and then we heard this morning Meg was saying ICSID has done.
Meg said that ICSID has done 380 virtual.
So ICSID has hit the ground running with virtual hearings. So let's talk about that. We know that ICSID, if you're having a hearing at ICSID, you are going to fall into the warm, loving embrace of that support structure. They will handle all the nuts and bolts that you need. That is not necessarily the experience at every institution. So, Stacy, can you talk about how did you make the pivot to the virtual hearing? Because I know your first virtual hearings were not at ICSID. So what did you have to do and how did you do it?
That's correct. It was definitely a little bit of a loop in the beginning because when it comes to hearings in person, because I do have so much experience, I kind of go on autopilot about what to do and how to do it. But the virtual world, it was a complete loop. So I kind of had to restart right from the very beginning and how to approach these hearings. How is it going to be held? Who is going to host it? So as Ashley mentioned, my first hearing was not ICSID, so we were on our own to figure it out. And I just kind of started to think, well, by this point, we were a couple of months into the pandemic already, so clearly other virtual proceedings had been happening, whether or not they're U.S. courts, whether they're, virtual depositions. So I actually reached out to some other trial specialists within Crowell & Moring to find out how they'd been handling virtual depositions, because I figured I could adapt that. We knew we wanted a third party to host because of privacy concerns, because of breakout rooms and things like that. So the trial specialists offered me some tips that they had from depositions and some court reporters that had been hosting hearings. And there we go, court reporters. Okay, they're going to know how to do this. So I reached out to a couple of court reporters that were recommended and thought that, okay, well, we can adapt this to a multi-party hearing. And that's exactly what we did. So we were able to bring in a deposition company. They had a host at the hearing. They would have a hot seat person who would be able to show documents on screen for us. This particular one did not host our court reporter because we had planned to be live. So we'd already had a court reporter contracted, which was fine. But it actually worked out really great. A deposition company is used to multi-parties. They're used to documents. They're used to all kinds of things happening. And by this point, we'd had a couple of months. So it actually adapted really well to using a deposition company. And we were off from there. I had also initially contacted some institutions. The AAA, for example, they had pivoted towards virtual arbitrations, as well as a couple of institutions, including one up in Canada. So there are companies out there, and it was just a matter of trying to figure out who they were and how to find them. But deposition companies were a really great place to start.
Well, and so Christine, Stacy's mentioning that she called deposition companies. How can case teams find the vendor that best suits their needs?
Sure. So in a way, I think it's somewhat of what Stacy's already talked about as far as going to who you know already. So if there is, let's say you have to do something that you haven't done before, you can maybe reach out to one of the vendors you've used for another service, but we also sort of have a network among us where we sometimes get asked for other services, so we might be able to help you with that. Another area that I was thinking of as well is tapping into your own colleagues at the firm. I just recently was reviewing it, and about a little over 90% of the business that we have at Sopra comes from repeat clients and referrals that are within a firm. So ask your colleagues, ask around as you did as well, and into other areas of the firm. They might be able to help you with that. So those are always the starting points, and then I think usually you can get a sense of where to go next once you ask your known contacts for referrals.
Great. And Jackie, maybe you can address a little bit. What is it that parties need to successfully hold a virtual hearing? Is it some huge technological fireworks show? Like, what do they really need?
Well, one of the early challenges that we had during the pandemic was that normally when people testified or when experts or witnesses would testify remotely, they were doing so from their beautiful offices, for example, like this one, with all this technology at their fingertips. But during the pandemic, as we all know, people had to connect from their kitchens, from their living rooms. So that posed an early challenge for us at ICSID because we needed to make sure that everyone had the proper equipment
to connect, and that meant making sure that everyone had screens, cables, microphones, and more importantly, stable internet connections. And so we made it work. It required a lot of testing. We tested a lot individually with the arbitrators and tested with the participants individually. And that's where I really came in, because the secretary of the tribunal needed to focus on other matters with the tribunal. So that's where I stepped in to make sure that all the participants were comfortable with the technology and were able to connect.
All right, so this part I'm actually really excited about. Kelby and Stacy have shared some photos, and Anna, if you could load those, that would be wonderful. And Stacy, I think the first couple of pictures are yours, so I'm going to let you describe what the audience is looking at here.
Yeah, so this is what you don't see. This is my attorney setup for a hearing. So you will see each attorney is given 2 laptops, 2 monitors, and if needed, the lighting. You can see that the laptop with the Zoom screen up is connected to the Zoom screen. And the only thing running on that computer is Zoom. There is nothing else running at all, so that the Zoom will be live and active the entire time. No one has to jump around screens. No one has to worry about minimizing something and missing something. So the Zoom is always running. On the right-hand side, you will see there's a docking station, and that is where the attorney will plug in his or her firm-issued laptop, and they can run pretty much everything else. They can be running their Outlook, their Skype, any attorney notes that they're taking. They could be running the hearing transcript, pretty much doing anything else he or she needs to be doing during the hearing. But the Zoom is still running independent. There's no eyes darting around screens, etc. And then you can see, hopefully it's a little small, but you can see between the 2 monitors, there's a camera. And the camera is independent of the computers, so we're not relying on the usually pretty terrible internal cameras that computers just have. And it also allows for a nice forward-facing view, so no one has to be looking down or up. The speaker can just speak straight into the camera. So can you go to the next slide, please? And then you can actually see, this is what is actually seen on screen. It's just that clean background, and for us in this particular room, just a small painting in the background. That's all you see. You don't actually see everything going out on the other side. So next slide. And then lastly, this is what I have for my witnesses if we're able to have witnesses live with us. It's just a slightly smaller version. So again, the witness is going to be connected to Zoom, and that Zoom is going to be connected to a screen, so they have a nice big screen to be able to see any documents that he or she is being shown. And then again, the camera, so they can have a nice forward-facing view. Again, we don't want anyone looking down, we don't want anyone looking off to the side, we want them to be looking forward, because ultimately what we want to do is try and create eye contact. That's what we're trying to mimic, is eye contact. And I know that's not always easy on the screen, but we want to try and make as much eye contact as possible, and looking forward is one of the best ways to try and mimic that. So next slide, please.
So before I go into this, when I was at Arnold Porter, we were going through an office move, and right at that time, everyone's offices got packed up. Everything's in boxes, so no one was coming into the office to do a nice virtual hearing because there was no background, there was no setup or ed tech. And at the time also, there weren't all these webcams. I think if anyone remembers at that time, there was so much shortage of supply. So one of the first things we did is this was actually just a workroom, where just a bunch of boxes were and stuff. So what you see on the screen is just a workroom. And the initial thought was like, well, could we make this into sort of a Zoom room, because the existing firm technology with the conference and Polycom system weren't built for that. So we had to figure out, okay, well, if there's an Ethernet line, if there's lighting or something, can we make this make something work? So this is actually what this looked like. And if we go to the next slide, we thought, okay, well, there wasn't a background, there wasn't anything back there, so I thought, okay, well, we can make a little fake background here with a little camera and stuff. And that was the other thing with the virtual hearings. It wasn't like if you're an arbitrator or an attorney presenting, you're just looking at one person. You're looking at the screen and such. But if you are someone who's following along, you're looking at the transcript, you're looking at the notes going back and forth, you're looking at your email. You're all communicating, so you need more than one screen. So in this case, we had like these 3 screens going back and forth. And so, and then at one time, it's like, well, sometimes people don't want to sit, sometimes they want to stand. So if we go to the next slide, we put another one on the side, and we're just like, okay, well, we'll just put a little fake background there with books, and that one can actually be standing. There's actually a little podium there. And then at the end, I think the next slide, then the idea was like, well, can we actually make a real background? Because at this point, the virtual background doesn't really, it doesn't look really great. And this, I think, Meg, in the beginning of her opening, was talking about sort of virtual backgrounds, and when you have a witness, you turn off the virtual background because you can always like mimic or have notes hiding or something like that. So you want to have a sort of 360-degree angle. So one of the things we said, okay, well, let's get rid of the virtual background. And if we go to the next slide, we went ahead and just like, okay, well, let's just add whatever books we could find and just started adding this here. And finally, this started looking decent. And now we go to the next slide. This is sort of what now it looked. We have the partner presenting and with associates sort of mimicking passing notes, or somebody's sharing the screen and trying to make this actually work. And I think this was a great use of the technology, of what we had. We even had a little platform back there for anyone who was too short to like reach out, so that we don't have to move the stage back and forth and such. But we were trying to make whatever we could work, and I think it was an exciting time, but also it was like a lot of hair pulling time. We were like trying to figure it out, and this was a room that nobody wanted to use, and we actually made it useful.
I mean, I love these pictures. I think it's really fun for those of you who haven't seen what, it's like a duck gliding along on top of the water, and then you see like the legs paddling furiously underneath with the lighting and the camera. And recall Stacy and Kelby were setting this up for multiple attorneys sometimes. It's not always just one setup. It depends on how the hearing is being conducted. But I thought that would be an interesting view for those of you who haven't yet had to set one of these up. So let's talk about demonstratives in a virtual hearing. And maybe, Kelby, you could just briefly address, because it's different than it used to be.
Yeah, well, if anyone right now is joining us on Zoom and you have it on full screen mode, one of the first things you'll see is that the picture is probably covering up part of the screen. So that was one of the first things we started realizing is, oh, I probably don't want my traditional PowerPoint where it covers the entire screen, a lot of text. We didn't like that to begin with, but now we really can't like that. Because the faces are going to cover the screen. Now that Zoom introduced closed captioning, now we can't have it on the bottom of the screen. So we can't have a lot of text everywhere. So it's like, okay, centering it, changing your demonstratives for the virtual hearing, knowing how it's being used. I've seen some really great presentations by professors where they actually embed their face into the PowerPoint. So they're like, you can still see me, like you're like, so you're not like sort of hiding away or looking at 2 different screens. So the demonstratives, making more use of them actually during this time. You've got a screen right in front of the arbitrator. Show your graphs, show your maps, whatever it is that at first you were hesitant about spending a lot of money blowing up on a cardboard. Now you can just pull up things that are going on, highlight text that the witness is saying as they're saying it. That made that aspect of where we could use technology to our benefit. That was actually an interesting time.
All right, so Christine, virtual hearings, are they here to stay?
They have to be, yes. Again, I hope many of you heard Meg speak this morning, and I think that obviously she's speaking for ICSID, but I think it'll be the same across the board for other institutions and just all arbitrations. I think what we found was without any other options, we had to embrace it, right? And even for some arbitrators or practitioners who maybe were not as comfortable with technology, now they are. One way or another, we're at that stage. But I think that one reason why I really push for us to consider this as we do hopefully begin to emerge somewhat from this, what we've all faced over this past year and a half, is there's not only a cost-saving benefit at times with using technology, but then there's a whole other component of it that I urge everyone to consider. As Ashley mentioned at the beginning of this presentation, I am part of the global steering committee for the Campaign for Greener Arbitrations, and it's a wonderful initiative. If you haven't checked it out, please do so, and you can sign up to take the pledge. You'll be notified of all of the developments. We're working on a lot of exciting things, but in short, what we're working to do is to engage all actors in the arbitral community, so specialists, paralegals, vendors, practitioners, arbitrators, institutions, to approach arbitrations with a mind toward reducing the carbon footprint that you leave behind. So we all saw in this world that we were, again, forced to change our ways, and there was, at least for a short term, a benefit to the environment, where we saw the air clearing up. We saw in many parts of the world, I'm sure you've seen images of the changes when we cut down our travel, when we cut down the pollution, there was an improvement. So again, I think now there are obviously various factors that will go into this, the decisions moving forward, but I think this needs to be at the forefront of your mindset when you're making decisions. And I think that kind of ties into, as Meg talked about today, maybe thinking about hybrid hearings too. You know, not just reverting back to our old ways when we can and going to do everything in person, but at least parts of the matter that can be conducted virtually can still be done so. And then, of course, if there's the need to be in person at times, it's understood. We do have to travel at some points, but just maybe paring that down a bit, paring down the paper that we're using. I think, again, maybe people who before only did a paper review of documents, now they see that you can do it and much more effectively by using technology. So I think that that's just one of the big takeaways that will hopefully be something that we can look back on and say that it was a benefit that helped us to shift how our practices operate moving forward.
Definitely. I think that's right. And Jackie, I'll ask you the same question. Virtual hearings?
Definitely. I think ICSID is very happy with the way the members of the tribunal and the parties have adjusted to the new normal. There are still some challenges that remain. For example, in one recent hearing that I had, we had the president of the tribunal in Geneva, a co-arbitrator in London, another co-arbitrator in Toronto, somewhere in Canada, and the parties in, one of the parties in Singapore. So a challenge that arises is that you're dealing with a big time difference between the parties. So one of the parties will have to start very early, 4 or 5 in the morning, and another party will have to end very late, sometimes 1, 2 in the morning. So that's a challenge that we're still trying to deal with and tackle. And I think, as you mentioned, hybrid hearings are a good alternative when possible. We had a recent hearing where the tribunal was able to convene, I think, in London, and that made it much easier with the time differences, and that went really well, I think.
That's great. Now, how have you seen teams adapting? And I'll ask Kelby this. How have you seen teams adapting with the work from home evolution that was thrust upon all of us with COVID?
No, initially it was really difficult because not everybody had multiple monitors at home and webcams and such. But I think now there's definitely a lot of us have gotten more used to it, made benefit of it. There was many times where I could have been at the office talking to a coworker, trying to talk about something on screen, but now we're all sharing screens, we're all sending files back and forth. We're much greener, which is great, but we've all now learned our sort of our tips and tricks on how to work a little bit better. I've had actual 2-week trainings, just all completely on Zoom, trying to figure out a better way of being a little more personable, and I think it's worked out great.
So what are some ways that your teams have maintained connectivity with each other? Like, for example, in the good old days, you used to have maybe a war room, which is like a big conference room that everybody moved into for some ungodly number of days. So how do you replicate that? Do you replicate that in the virtual space?
You can, and that's that really takes a lot of personality, to be honest. Whereas before you had the war room, you'd have a lot of candy and treats and good food, so people would come in. But now you have Zoom, and sometimes you would, especially if there was a filing and everybody needs to sort of communicate, I just keep a Zoom open the entire time. At one point, I had one open for like 48 hours. Just come in, ask your questions. Somebody's going to be able to answer your question. We might have music playing in the background. Somebody take turn DJing. Maybe somebody could, as we're working together, we might not be talking the entire time, but okay, someone's on the other line. I can see you. I just sort of can feel like that's a window into you. Maybe like a cubicle, like
Misery loves company.
right? so we can say, oh, but by the way, like I quickly just turn. By the way, are you working on this? And that way we can just be a little bit more efficient. But I think everyone has found sort of a way to make this work. And I think going back, a lot of us may still use that because we still have those difficulties. Or I might be working with a London office. Or I might be working in different time zones. I might be sort of away visiting family, so I can still communicate.
And Stacy, what about for your case teams? Have you done like the 48-hour Zoom, or how have your teams adapted?
So we actually work in teams largely that are cross office, even pre-pandemic. So it is not uncommon that I would be working with a team member from DC, New York, London, and Doha. Those are the 4 offices I support. Those are the 4 offices where we have international lawyers. So for us, I didn't feel like there was as big of a transition in the beginning because we were all so used to working cross-office. Of course, there is like the technology aspect, and that posed a little bit different challenge in the beginning, as Kelby mentioned. But I actually don't feel like we had as much of a transition period as some others. We have, in some instances, particularly where we've had large filings, kept Zooms open, for multiple periods, so somebody could just pop on. One of the teams I worked with when we were doing a large filing held office hours. So the partners would just open up a Zoom. They would tell the associates that, office hours for this partner are X to Y. I will be here, and my job is to answer your questions. So very much like law school. So it worked really great, especially when you had some more junior associates who had a lot of questions, who would normally want to sit in front of the partner and talk through something. This was a great way they could know that time was dedicated to them, that time they could screen share, they could talk through issues. And that was really great, and I think it worked really, really well.
Christine, how has your interaction with attorney teams changed with this work from home evolution?
Sure. So for what I noticed is pre-pandemic, I worked primarily with associates and paralegals who were helping with collecting the documents and whatnot. But I think because of everyone wanting to make that concerted effort to stay in contact and have communication flowing, a lot of my groups have expanded when I'm working on a particular filing. So maybe the partners are also involved on the email chains as well, just so that there's that immediate update on the status of our work that we're doing on the submissions. And so that was just one thing that's interesting, and it also led to a lot more interaction as well from the partners who were just chiming in, rather than, perhaps in the past the associates would just handle that and go talk to the partners afterwards once our work was done. So that was just something that I thought I think it will continue now too, as we, again, as things start to change, but it will just help with making it more efficient to stay in communication when you're working on different aspects of the projects.
Yes, I've noticed that my email volume has gone up considerably, but that is not necessarily a bad thing, because as you say, everybody is more in the loop than perhaps they would have been previously. Now, a number of us on this panel are old enough to have lived through several evolutions of document sharing technology, be it through VHS, purely hard copy, sending out CDs to people, then thumb drives. So, Kelby, how has document sharing in this modern age? How has that changed, and how are parties harnessing the new technology to their benefit?
Well, I do remember the CDs and I even remember trying to do it in Word and trying to hyperlink it so that it would hyperlink to the CD or something. But with the rules changing and such, it allows us to go into new technologies. With every time that we go into new technologies, we have to think about the benefits and the cons. Anything from like USBs, then we're talking about encryption and does it work on Macs versus PC, FTPs. There are all sorts of ways of exploring new technologies, but I think with document sharing, we keep advancing the ball because we want everything to work a little bit more seamlessly. However, we also have to think about, well, we don't want to just flood the arbitrator with so much stuff that they can't like figure it out. So that's, I think, where our roles here come in, where we want to make it as user-friendly and efficient as possible, so that anyone, the arbitrator and opposing counsel, witness, can go through it and see, okay, these are the files that pertain to this, and not have to hunt through a lot of the documents.
And Jackie, what is the institutional perspective on how document sharing has evolved?
Well, as you know, ICSID right now is going through a massive change, or has been going through a massive change in the past year with the going green. We've almost immediately after the pandemic started, we sent correspondence in all of our cases stating that we were no longer requiring hard copies of our submissions, which was huge because the amount of paper alone was a lot. And something that we've noticed since we've started doing hybrid hearings is that the parties are still sharing documents through Zoom and WebEx. So hopefully this means that we will no longer need hard copies of cross bundles and stuff like that. So that's a good, I think, a welcomed change.
Yes, lots and lots of binders that don't have to be printed, which I know, Christine, makes you happy. And so how has the document sharing technologies impacted your interactions with your case teams, Christine?
Sure. So it's really echoing what has been said here so far. It's just, I think there's a much wider acceptance now. It's not that as much of a reliance on paper. I don't think that we will revert to that much, and I think that's all very positive. And it's we're used to now using, just plugging in and logging in and accessing everything electronically. So I think that will continue. We still want to keep it very streamlined and make sure that it's user-friendly, so that if someone is not as comfortable with technology, they can still embrace it and be able to access the files that way. So that's pretty much the same thing that I think we're seeing across the board from everyone here, is just really edging out using paper and then relying now on the technology that we've had to use because of the pandemic, but continuing on with that.
Right. So one common theme that I'm hearing is that really the goal of our collective efforts is to help the arbitrators, the tribunal, process the information as efficiently as possible. And so I think that's something that sometimes the parties get hung up on, arguing about minutia, but really the end goal should always be what is going to benefit the tribunal and their understanding of this information as easily as possible. And so, before we turn and open up the floor for some questions, I want to end with each of you offering the audience just a piece of advice. So Christine, what would be your final takeaway, your piece of advice to the audience?
Sure. So it's what you just touched on now. It's keeping in mind, just I think stepping back and getting that bigger perspective of why are you doing all of this? Why are you considering using technology? And I spoke to an arbitrator at one time who said something that stuck with me, that the easier you make it for him to see what we want him to see, the more likely he is to do what you want him to do. And that really sums it up. You're wanting to make sure that the merits of your case are really at the forefront and are really being seen by your tribunal. And I think using the different technology that we've discussed today and just using different methods will help do that, to really hone that focus in on why your side should come out and be victorious in a certain matter. So by all means, I think we need to continue down this course.
Jackie?
Well, something that I hope all of you have taken away from this is that ICSID always strives to make sure that the cases move forward as effectively and efficiently as possible, and regardless of whether your firm has the specialized resources to do so, I think that's ICSID has in place a lot of resources to help both parties proceed with their case as effectively as possible.
Kelvin?
For me, like some takeaways I'd say is definitely reach out to as many people as you can about this profession. And by that I mean some of the best tips and tricks I've gotten were from vendors. When I would send something to get a hard copy, they tell me, have you tried this, have you tried that? Things that would make me a lot more efficient, formatting my documents, knowing how I'm going to submit a translation, help me think, oh, okay, now next time I'm going to do it this way. Reaching out to opposing counsel and seeing what they've done in others. Like a lot of them a lot of good people have done a lot of great things out there. And I've seen their filings, and I've learned from them as well. But also, I'm sure any one of us can also answer many questions. I'm more than happy to reach out and help out training-wise and such. I think the knowledge is only becomes better once we start to share it and develop it and actually innovate it and try to get out of sort of the bubble that we've kind of been in for a while.
So I think my biggest takeaway kind of echoes what Kelby just said, and that's using your resources wisely. So, I think not all attorneys know every single piece of the law, but they know how to go find it. Well, we're the same thing. I don't know every single answer. I know a lot of the answers, but I don't know every single answer. But I know how to go find it. And whether that be through a colleague, whether that be through a vendor, whether that be through any other resource, I know how to go find it. And that's the key. It's just using your resources and using them wisely.
And so speaking of resources, Jackie, could you just touch briefly? I know ICSID has a lot of materials on its website. Is that just for people who have cases at ICSID, or are there materials there that could benefit anyone?
I think, ICSID has a lot of, for example, I know that Meg did a presentation, our Secretary General, Meg Kinnear, did a presentation regarding virtual hearings. We have a lot of information on that. So I think anyone should visit our website to check out the information.
Great. Okay, so we do have a little bit of time. Actually, we were running surprisingly a bit ahead of schedule. So we took so long on our discussions before that we were sure we would run out of time. So we were all in our best behavior with our answers today. And now we have lots of time for you. So for our Zoom audience, if you have questions, please type them and I can relay them to the audience and give our panelists a chance to answer. And then if anyone in the audience here has some questions, just raise your hands. And I guess I can share my microphone? Yeah. Okay. Great. Does anyone have any questions here? Not to put you on. Oh, we have a question.
Thank you for the presentations. You all talked about how good and efficient you are. So I want to throw a wrench and see how you all might react to something that's hard. How do you each deal with multiple languages in an arbitration, whether it's in the documents or in the hearing itself? Maybe you have witnesses that speak a different language or are testifying in a different language, or you have a dual language arbitration. I don't know. I'm just trying to make things complicated and hard to see how you might deal with it.
When you get something that complicated, you gotta break it down. So what is the main language that we're gonna be dealing with? So if you got a lot of languages, is English the main language? In which case then we gotta focus on translating everything into English. If it's gonna be run I've had arbitrations where it's English, Spanish, and French at the same time. In which case, well, then I've got a lot more documents, a lot more translations that I have to juggle. And then there can be arbitrations that I don't speak the language, so I don't know what I'm looking at. So I'm really then relying on my co-counsel, if there is one, or if there is an in-house somebody who does speak the language, then I'm coordinating a lot as to what am I looking at, how do I organize, index it. So in that sense, I would say, well, I need to simplify the complex parts so that then I can figure out how to tackle it.
I would also say it all comes back to your terms of reference or your procedural order. The arbitrators generally will spell out for you what is the language of the arbitration. If the arbitration clause itself doesn't already, do you need to have the entire document translated, just part of it? Does it need to be certified? Can it just be a non-certified copy? Work with your vendors. We've got one of our translation vendors here in the audience today, but work with your vendors to see how you can get batches of documents translated. We've had a bunch of cases in the more commonly spoken languages where folks in our group already speak them, but then we've also had cases that are just nobody at the firm speaks that language, and we've reached out to local law schools and tapped law students to come in and work with us on a contract basis to help us review boxes of documents. You have to get creative depending on what the languages are, but your guiding light is the terms of reference, the arbitration clause, what the tribunal has told you that they want.
So just a final small comment on that. We had an arbitration, virtual arbitration, which involved translation. And at first that was a little bit of how are we going to do this? But Zoom actually does have multiple channels. So it does have an option for translation. So it did require a little bit of testing because when you're on multiple channels with Zoom, there's the potential you have the hearing overlap. First you get the Zoom lag, and then you get the Zoom overlap from the multiple channels. So that was a little bit of a wrench at first, but it actually worked out really well. So even if you have translation in a hearing, you can still have a translator through Zoom.
One thing from my perspective with the translations is we recently had an investor state matter where at issue were some of the translations of the terms, and so I saw how we used the linking quite effectively to help show the original documents, and the matter was, the primary language was English that the parties were working in, but we were able to quickly provide access to the original documents, and the feedback that I received was that the tribunal was very grateful for that, to be able to really toggle back and forth quite easily when they were reviewing the written submissions. So it's definitely, again, I think it's just communicating with your vendors or with your in-house team on how you can make sure that all of the languages are accessible so that they can be reviewed thoroughly.
Hi. I work with JAMS, and we noticed over the kind of switch to virtual increased participation from some of the parties, and I was wondering if you could talk about ways in which you interact, even in the very process of getting everybody that's going to be participating comfortable with the tech as a kind of impact on the overall process, and if you think that's made any sort of an impression on how willing parties are to go forward with these kinds of complex international arbitrations online.
Testing, test once, test twice, test third time, test individually, test within your own Zoom, test with the arbitrators, test with the institution, and then test again. That's what it comes down to, because the more comfortable your attorneys feel, the more comfortable your witnesses feel, then the more when it comes to the actual hearing, the actual day, they're going to feel more comfortable. I can't be in their own homes, so unfortunately I can't be there to set up. So a lot of times I'll just even do internal Zooms. I can tell you at 2 o'clock in the morning the night before one of my counsel's first hearing, we were Zooming to make sure her sound was working again, make sure her background looked good, make sure she felt comfortable. But it all really comes down to testing. The more you can test and the more you can do testing with the, individually, you don't need the full team each time. But the more you test, then the more comfortable everyone will feel. And that's ultimately what it comes down to.
I would add the testing is really, really important. I don't think there's like one-stop shop when it comes to the technology. Everyone's home is going to be different. Everyone's situation is going to be different. There are so many microphones out there, whether it's headsets, microphones, lapels. So it's really like trying to work with someone to see what's going to be comfortable for them, because if you just give them this box, use this equipment, they're not going to use it. So right now, like, this was a whole different setup. Like, how do we don't have built-in cameras and stuff. I'm using an iPhone for this setup because we didn't have a lot of technology. I put it on a $60 cart, and we're just like moving things around. We have to figure out how to make the technology work for you so it feels comfortable. Monitors that look good, or some people might be sensitive to blue light, so you can't have 4 or 5 different screens on. Maybe just smaller screens. Some people like to work just on your laptop. Well, how do we make that work? There's actually some pictures, actually I didn't share, but where arbitrators at webinars previously were sharing what their setup looked like, and some of them, because they were just going to be staring at the parties all day long, they had this large, like 55-inch screen with a camera right in front, and that was what worked for them, so that they could be on their sofa and they could just watch. So it really is like just kind of testing it out. I think I've done and redone my like home office like at least like 16-17 times, back and forth, just built it, rebuilt it, just to figure out like what does a witness or somebody or attorney, what kind of equipment are they going to feel comfortable with. And there's so much out there. Definitely consult somebody, like a specialist or somebody who's done a lot of these things. I'm sure the World Bank probably has their own tips and tricks as well. But yeah, the testing and be comfortable, because you're going to be using this room for a while.
Do we have any questions from our Zoom audience? Oh, sorry, one more question?
Oh, sure. Thank you, everybody, for such a great session so far. The theme of at least kind of the first part of the talk was long-term considerations in how to increase efficiencies around these arbitration proceedings. And on the provider side, we're accustomed to both kind of very short transactional one-off projects, but also larger case-level projects that can span months or even years, putting into place things like data repositories and detailed project management chronicles and things like that. But a lot of that stuff is, we're accustomed to doing that on the litigation side. And Stacey, you said that the vocabulary between litigation and arbitration can be very, very different. So what are one or two maybe top best practices that you could recommend for a support provider that would allow them to contribute to the efficiencies of an arbitration rather than a typical litigation?
That's a really good question. So what would I tell or what would I want from a provider to be able to provide me more efficient? The terminology is important. Understanding that when I'm doing a memorial, that I'm dealing with a brief, I'm dealing with witness statements, I'm dealing with exhibits, I'm dealing with expert reports, I'm dealing with basically what you would normally do through an entire discovery phase all at one time. And I honestly think just understanding our procedure and understanding that we don't take depositions, unless specifically allowed in special circumstances. We don't really do a doc production in the typical way that a litigation would do. I will often receive documents when we do our document productions that aren't Bates numbered, things like that, where as in a litigation, that would be unheard of, to send a doc production with no Bates numbering. So I honestly think the number one thing you can do is just understanding the procedure of how an arbitration works. And I know that's really broad and really general, but just understanding things that we don't do, but as compared to a litigation, but are very standard in an arbitration, like Redfern process. If I told you tomorrow, like if you weren't in this, if I told you I'm doing a Redfern, anyone who does an international arbitration would know, oh, they're in the document production phase. They're dealing with doc production. But if I told somebody in litigation, oh, I'm working on a Redfern, they would look at me like I have antlers. So, you know, it's really honestly about the procedure, and the number one thing is terminology. If you can understand the terminology, then you can understand what phase I'm in and what I'm doing. And by that, what support I'm going to need. If I'm in a memorial phase, I'm probably going to need translations. If I'm in doc production, then maybe I'll need help with, you know, extracting documents from a client to be able to for the attorneys to do a doc review. But if you understand what phase I'm in based on the terminology, then you're going to be able to understand what my needs and our case team's needs are at that point.
So our time is coming to an end here, but I will just address one quick question. Our Zoom audience has asked, you know, some courts for enforceability need hard copies. And so, you know, we've talked a lot about virtual hearings, but just to respond to that, we still can send hard copies where it's required by an arbitrator. It's just that from a grain perspective, from a cost perspective, where the arbitrators and the parties are willing to accept virtual documents, it's a win for everyone. But if a court needs or a tribunal is requiring hard copies, that is still something that can be done. With that, I think we have gone over our time slightly. I'm going to give the microphone back to Jose Antonio. And I'd like to thank all of my panelists. Thank you so much.
Well, thank you, Ashley, and thank you, everyone here. It was truly an amazing panel, and what we wanted to bring to the Washington arbitration community, both in DC and elsewhere, is that international arbitration doesn't happen only between a state and an investor. It doesn't happen only between two private parties. It doesn't happen only between counsel, opposing counsel. It has a whole range of warriors behind the scenes working to it. You know, you see vendors, you see amazing specialists, paralegals, legal assistants, and that has been sort of overlooked for a long time. I think that it was time to give the floor to those that have most experience in international, both commercial and investment arbitration, and are working very hard in creative ways to make things happen. And as you have seen, it happens institutionally, it happens also in firms, it happens behind the scenes with providers. So this is a part of our key community, and we wanted to bring to everyone, not only in DC, but to people that are in pretty much the four corners of the world, what is really going on, and how their knowledge and their creativity is being brought to fruition to make things happen. As opposed to in courts in various countries, international arbitration has been able to adapt, proving that it is a means of dispute settlement resolution that has grind and will make it happen for a long time. With that, I would like to give a real in-place round of applause to each one of our panelists and to our moderator. And now we're going to go into breakout rooms virtually. Of course, we're not going to have in-person virtual rooms, but we've found that creating the breakout rooms is useful for people to mingle and to know each other. This time it won't be with the panelists because the panelists are here, but you're welcome to go into breakout rooms and you'll be for 10-12 minutes, and then the next session, I believe it's at 4 on evidence, and wow, second edition keeps going on. Thank you. Bye.